Okay, so I will be explaining about the introduction part. So for the introduction, any person whose land has been reserve land has been leased to a temporary occupation license, has been granted in respect of any land, shall be entitled to exclusive enjoyment and use of land. So such rights is nature of proprietorship, which means that when someone interfere with these rights, the landowner may sue for trespass. Okay, so I will be continuing by explaining about the case law. So the case law I choose is here Corbett versus Hill for the introduction part. So the owner of a land is the owner of everything upwards into the limited skies and downwards to the middle of earth. So however, this right subject to many qualifications under English modern law. So for example, an owner of land do not have right to call oil or any treasure trove discovered on the land. These commodities are vested in the state. So this is similar to Malaysian land law, where a person will not have right to oil, minerals or treasure found in his land is covered under Petroleum Protection Act 1934. So for the natural right under NLC, once land disposed by SA, the land proprietor, the license and the lease of reserve land are entitled to enjoy land as prescribed in NLC 1965. So their natural rights over the land are described in section 44 and other ancillary and subsidy rights are in section 45.
Assalamualaikum Madam Bella. My name is SALSALBILA AZNI Binti AZMAN. I'll be explaining about the right of airspace. First of all, is airspace part of the land? The land maxim stated that a person who owns land owns everything above it. In section 42 suggests for the separation of airspace and land, while section 44 allows owner of alienated land TOL or lease to enjoy the exclusive use and enjoyment of the space of the airspace. Common law and statute in England overruled Ladin maxim, giving the phrase "to the heavens" a restrictive meaning to balance the right of individual with public rights. Trespass. How about trespass? Trespass is an unauthorized intrusion into another person's property, even when there is no physical harm, if the aircraft was flying within a reasonable height and for a valid purpose. It is not actionable unless it causes harm to the land, property or use of the land. Thank you. I'll pass to the next presenter.
A very good day to my lecturer and my fellow friends. My name is PUNA from RAMANATHAN, studying bachelor's in law commerce. So today I will be presenting my part based on rights to airspace. So my subpoints are summary and suggestion and summary. So for the suggestion is developers should get consent to intrude neighboring owners' airspace, and then they had to prepare to pay compensation, and then prepare a proper agreement and to increase insurance coverage. And for the summary, owner of the land has the right to use, enjoy, but has no proprietary right to airspace above the land. Court always inclined to give certainty to right of landowners. Nevertheless, the landowner only has exclusive right but not absolute. And developer must get consent and prepare agreement for license to use airspace. So that is all from me. Thank you.
Good day, madam. I'm HEMAH MARUTHUVANAN. Now I'm going to presenting about Civil Aviation Act 1969. Okay. Section 19 subsections 1 Civil Aviation Act 1969. The provision states that no action can be maintained by landowner for the nuisance or trespass simply because of the flights of aircraft at a reasonable height, other circumstances considered. However, the pilot must observe all the flying regulation as prescribed by other relevant statutes. This is not an absolute exoneration of the aircraft owner from any or all types of liabilities on trespass or nuisance. Section 44, subsection 1A of Civil Aviation Act 1949, an owner has the exclusive use and enjoyment of so much of the column of airspace above the surface of the land and so much of the land below that surface as is reasonably necessary to the lawful use and enjoyment of land. Next, the service owner rights extended downwards sufficiently to prevent trespass by the tunneling under the surface or to give rights over minerals. Example of the case, Chen Yu Q against Angka Samas Sentian Berhad 2003, which a landowner is said to be entitled to exclusive use and enjoyment of his or her land and the airspace above it.
A very good day to Madam. I am RUBASHINI MALAR Anapurupan PARITHY. Today I will be presenting my part which is on right to underground land. Underground land refers to a space that is situated below the ground level. Section 92A National Land Code 1965 has the defined meaning of adjoining underground strata and underground land as follows in the slide. Next would be ownership of underground land. In common law, we have a maxim that says the owner of the surface also owns to the sky and tapped. In Malaysia, we see the landowner can utilize the land as deep as he wants with the full exclusiveness, and it's stated in the law as well. Next, we will be focusing on the utilization of underground land, where we do have a specific section like section 92B clause 3. Next, move on to the depth. The state authority must specify the depth which is not less than 6 meter underground just to ensure it can be used for its intended purposes and it is safe. Condition for adequate safety features will be imposed so that the underground land will be very safe and it would never become a threat to the public safety. And next we have a JKPTG circulation, where the depth of ownership in agricultural land should not be less than 6 meter when it comes to industrial and building, and it should not be less than 10 to 15 meter. Then we see in the case of Sri Kajang Products Sanju and Berghard against Maybank Finance, BHD and OR. So this case about like permit to extract and remove the rock material. So it was held that the plaintiff has a permit to extract and remove the rock material. It must include the erection or installation of necessary equipment.
Good day, madam. I'm HEMAH Madhuvanan. Now I'm going to presenting about antiquities. Antiquities are relics of past that museums are interested in preserving. So, definition of antiquity, subsection 1 of the National Heritage Act 2005. Any movable object which is reasonably believed to be at least 50 years old, any part of any such object which has at any later date has been added, reconstructed or restored, or any human plants or animals remain which is or is reasonably believed to be at least 100 years old. So next second is section 47 of the National Heritage Act 2005 mentioned that the person who finds tree antiquity must immediately notify the Commissioner of National Heritage, authorized officer or the district officer. Failure to do so is amount to an offence. And section 48 of the National Heritage Act 2005, the antiquities shall be absolute property of the federal government, provide that where the object is discovered on alienated land, compensation may be paid to the owner of the land. Next, I'm going to present about the treasure trove. Okay, based on treasure trove, section 2 of the National Heritage Act 2005, Act 645, any money, coin, gold, silver, plate, bullion, jewelry, precious stone, or any object or article of value found either in or in anything affixed to the soil or the bed of a river or lake or of the sea, the owner of which is unknown or cannot be found, but does not include any tangible cultural heritage. Second, Section 74 of the National Heritage Act 2005 Act 645, any person discover any treasure trove, notice must be given to the commissioner or the district officer. Lastly, Section 79 of the Heritage Act 2005 Act 645, reward may be paid to the finder and to the owner of the land in which the treasure trove was discovered at the discretion of SA. That's all from me.
A very good day to Madam. I am SHANUSYA RAJAN and I will be present about the right of the support, which is under section 44 bracket 1. Any person or body to whom land has been alienated, receive land lease or temporary occupational license are entitled to the exclusive enjoyment of the land. So the right, not absolutely right, they are exclusive against the third party. So the second section is section 44 bracket 1 bracket B, which is a landowner is entitled in certain circumstances to have the land and supported by neighboring land, as well as the right not to have the support removed. So the right to the support of the land is naturally stated by any adjacent land and all other natural rights subsetting in the respect. This right of support is a negative right in which it refers to a right not to lose natural support from the adjoining land. This right cannot be interfered by others. The neighboring land is expected to obtain support from the adjoining land thought it is subject to certain qualification. In order for a person to have right of support, there are conditions that must be fulfilled. The land at the lower level must support the land above it. The land must be adjoining with each other. However, the ownership must be separate. The land must be in a natural state. No additional support is to be given behind what is on the land. Finally, the owner cannot expect additional support from the adjacent if his land is proven to be in its weakened state. For example, there's a case law in Faunak Sandram Bahar versus Atlanteras 2020. It is concerning a suit in trespass and against the defendant in respect of a piece of land in Hulu Langat, Selangor that belongs to the plaintiff. In substance, the plaintiff's claim was based on an wrongful removal of earth from and the leveling of its land in the course of the construction of a retaining wall on a road received adjacent to it. The wrongful removal of earth result in warning reduction in health along the affected part of the plaintiff land. It was held that it was not trespass or damage caused in the execution or conduct of an irregularity activity.
So to be concluded, subject to provision of this Act and other written law, an owner has the exclusive use and enjoyment of so much of the column of airspace above the surface of the land and so much of the land below that surface as a reasonably necessary to the lawful use and enjoyment of the land. Thank you.